So welcome everybody. Very, very happy to have with me today, once again, Pauline Tesler. And she's been generous enough to be willing to rejoin us, because last time we spoke, Pauline, we kind of touched on the work you're doing now in integrative law, but I don't think we did quite enough justice to it. So I appreciate you wanted to come back and talk some more about that. So,
I'd love to talk some more. Thanks for inviting me.
So why don't we start with the simple question? Tell us about integrative law. What is that?
So, integrative law is a relatively new movement that has emerged over the past several years as, I'm sorry, I'm going to have to read that because I lost what I thought I had. My apologies. So integrative law is a movement that's emerged in the last several years in which lawyers who've been working in a variety of disciplines, for example, restorative justice, collaborative practice, mediation, mindfulness in the law, and much more, as well as those of us who have become really interested in the interface between doing effective conflict resolution work as lawyers and what we can learn from the emerging discoveries in the neurosciences and psychology. All of that's coming together, and I and a couple of other people who are out on the edges of what we're calling the integrative law movement are starting to understand how all of these pieces actually fit together into what I'm thinking of as a new jurisprudence. It's a jurisprudence of human conflict resolution as it manifests in legal problems. That's kind of a mouthful, but that's one way of saying it.
Yeah. It seems to encompass a great number of things then. Is there a particular source from whence it derives, or just kind of boom? Is there a target date?
In my personal trajectory toward integrative law, and I don't think there are very many that you can look at yet, but because it's new, it's on the edge of the development of our profession. But the way that I've come to see that this is really important for us lawyers to learn is through my work in the collaborative law and collaborative practice movement. As you know, but maybe others don't, I've been working in that model of legal conflict resolution for more than 20 years now. And especially, I've been writing and teaching about integrated interdisciplinary team practice, in which lawyers are really sharing the sandbox quite fully with mental health professionals and financial professionals to try to deliver a congruent kind of message and process that helps people get to where they say they want to go. And from doing that work, I've been teaching increasingly advanced kinds of workshops and seminars to collaborative lawyers who've been doing it a long time. And where it took me was that what we all needed to learn was a whole lot more about how human beings as organisms actually experience conflict and actually make decisions. And that's taken me right out there into the realm of brain science, positive psychology, cognitive and behavioral psychology, neuroeconomics. And I'm fascinated by it, and particularly I find that most of what's been available to us as lawyers in the way of learning in those spheres, which are exploding with discoveries, mostly it's being offered by the scientists who are actually working in those fields, or by journalists who are translating it in general terms. But what I have found is that I'm able to take discoveries from these fields and translate it into practical tools that lawyers can use for our work. And for that, it takes a lawyer, really, somebody who knows what our work is about. So my trajectory has been to start studying and working alongside scientists who are doing this work, and to learn how lawyers can make practical use of it. So that's how I got there.
You talk about talk about it as a new jurisprudence. And I know with our off conversations as well, and even on your internet presences, there's a reference to this as restoring law as a healing profession.
Yeah, that's kind of the tagline of the Integrative Law Institute, which is the program that I've started to do this work, is reclaiming law as a healing profession. And one of the things that actually strikes me as a little bit amusing is that as I was doing research about the roots of this approach to legal practice, of course I found the quotations that we've all heard from Abraham Lincoln and from Gandhi, and their discoveries about conflict resolution as lawyers. But what I hadn't expected was that Warren Burger would have said one of the most cogent things about reclaiming law as a healing profession. He said, something like this: should lawyers not be healers, healers not warriors, healers not procurers, healers not hired guns. And that just about captures it. And then the question becomes, well, okay, that's what we're trying to do. How do we do it? And for me, the key to moving into this much deeper and broader understanding of what the lawyer's job is to unseat sort of 18th century Enlightenment rationalism as the boundary and sole vehicle for doing a lawyer's work, and to become much more humble about the place of rational processes in human decision making. That's not easy for us as lawyers to experience, because we self-select into a field that prioritizes that. In fact, nothing else is permissible. If you've done any work in court, you know how welcome emotion is in the courtroom. But what the sciences are teaching us is that emotion drives the train, and that what we think of as purely thought-based analytic processes are really rationalizations of what are fundamentally emotional, physiological impulses towards solutions. So it's like pulling back the curtain and discovering who the wizard really is. It's emotion.
And I know that what appeals to me about all this is, and what comes up for me is around the notion of disputes at all. I know in terms of, as you know, I've worked myself now in collaborative for about 12 years. You trained me, and so I've launched from there. But I've come to a place where I find really offensive, I don't want to go that route, but wrong, incorrectly stated, the notion of alternative dispute resolution. And at the center of it is this notion of dispute at all. And some of that, it seems to me, ties into healing in doing collaborative practice and collaborative divorce, where even though we're ending a marriage, we're trying at the same time to heal a relationship between the...
Precisely.
Go ahead.
The way that I've been, I keep trying to find very succinct ways of encapsulating these ideas that those of us like yourself who have been doing this for any length of time really know in our bones. And one way that I've been putting it recently is that legal disputes get resolved by pieces of paper called settlement agreements and judgments. But the conflict that fuels the legal dispute rages on. And too often the work that we do when we think that a settlement is a piece of paper with ink on it, too often the work that we do actually throws fuel on the flames, and we leave people worse off than they were before we started. So that what we're trained to do as lawyers is to disregard all of the messy operatic stuff that clients bring into us when they come with the narrative of their conflict. And we're trained to abstract it into terms that are justiciable, that judges are allowed to make decisions about. And in doing that, we're essentially telling our clients that most of their story, most of their pain, and most of their experience is simply not relevant. Well, they've come to us to help them get out of the pickle that they're in. And what they've got is a fractured human relationship. And it remains fractured without any constructive intervention when we work in the existing jurisprudence that says our job is to get them to a piece of paper. So integrative law is really, I don't like to use the terms holistic or humanistic so much, although they are, this way of working is both of those things, because there's been a whole lot of cultural stuff attached to it that marginalizes things that are called holistic or humanistic. But that's really what we're talking about with this new jurisprudence, is looking at human beings, not abstractions, but human beings as they actually are experiencing the fracturing of their lives. Now, this obviously does not apply to Microsoft versus Google. And so there is a sector of our work as lawyers that this really relates more to. I just lost your audio completely, Carmichael. I'm not hearing you anymore. I've lost you totally.
So good of you to notice.
There you are.
I had my mic on mute because of the sound issues we were addressing before. So
Okay.
I was wanting to ask you about that, whether there are some types of, I don't even know what the word would be, things, matters, conflicts for which integrative law is not necessarily at the center of how to approach it, things like that.
This is an area where I'm really still thinking through what I believe to be true, but I'll tell you, this is a work in progress, what I'm going to say here. But to begin with, I think that any lawyer is going to do a better job at anything we do if we can see ourselves as participants in a problem-solving system of which we become a member as soon as we're hired on to represent anybody, which I do not think is what we're taught about our role. I think we tend, as conventional lawyers, to see ourselves as a kind of invariable constant. I'm always me. I always do what I do. I'm consistently rational and capable. The only thing that changes is the clients and their problem. But of course, that's not true. Anytime any human beings get together to do anything, you've invoked a system that changes with the presence of any human being in it. So who I am matters. And what my biases and habits and strengths and characteristics and personality and character are all matter. So from that perspective, any lawyer doing any work is going to be better at it, I would posit, from having discovered the nature of human conflict and decision making. But having said that, this approach, I think, is optional. Lawyers can still do okay with conventional jurisprudence and skills if they're representing Microsoft and Google. The clash of large corporate interests about the bottom line. Granted, it's human beings who have to do the work of resolving those clashes, but it isn't fundamentally about relationships, with very rare exceptions. I'm sure there are some, but very rare exceptions. The other area, big area, where I think it's more optional whether you learn about this, would be encounters between individuals and the government, or the government and individuals. Some of those encounters are involuntary for the individuals, and some of them are voluntary. But when you're talking about the criminal law, you're talking about involuntary contact. And I think criminal lawyers probably could go about doing their job just the way they do it, given the limitations of the actual system that processes criminal matters. But they're going to do a better job of it if they know more about how the human beings are operating. And I do know several criminal lawyers who are working with restorative justice, which is one of the vectors of integrative law, to great profit. But I do think it's not mandatory, in my scheme of things for a criminal lawyer to know about this, although it's desirable. Then there are things like civil rights matters and law reform matters. The law is magnificent about the individual calling the government to account in those ways. And I don't think that really, that's the only place where I would agree with conventional jurisprudence that says the emotion really is irrelevant and a distraction. Because that really is about the majesty of the law in the 18th and 19th century sense of it. The clash of ideas, the clash of principles. And I admire that greatly, and I don't think integrative law is by any means essential there. But when you've got human beings whose personal relationships are crumbling, and the dispute grows out of that, the conflict grows out of that, then I think, from where I sit, I'd like to see our profession move toward an embracing of these skills and understandings as part of the job description. You got to know about this because you're going to do, I don't want to put a judgment on it, but you're not going to do work that's as skillful, as deep, or as helpful without it. And it seems to me we have a responsibility to be those things: skillful, effective, conflict resolution professionals when human beings have their relationships fall apart. We owe them something more than abstraction.
It has always struck me that the kind of the guiding principle of the litigation framework, our standard jurisprudence, is that solutions are best achieved with a coldly rational mind. And
yeah, that's the essence of the old paradigm.
Yeah, and so what we created was a dichotomy, a split person, as you will. The client, who was this bundle of untamed and ununderstandable emotionality, and then there is the agent for that client, who is the embodiment of pure reason, with no emotion whatsoever.
That's it in a nutshell.
Okay.
Right, and anytime that emotion rears its ugly head in that model, it really is interfering with the work of the lawyers. It's a distraction or worse. Mm-hmm. And the most advanced forms of practice in that paradigm, the most sophisticated practitioners, have come to understand that maybe they can send their clients out to get fixed to other professionals so that then the client can come back and behave and let the lawyer do the rational, cold, abstract work of the agent. Actually, there's a theatrical component of it too. But still, when you come right down to it, the job is to get the job done in a way that the lawyer understands as a matter of rational analysis and focused strategic purpose. So, yeah, that doesn't help somebody whose small dental practice is falling apart because one of the new associates, do you call dentists associates? One of the new dentists who's come into the firm is accusing the senior partner of sexual harassment. You know, this abstract, rational lawyer as cold agent just is not going to get the job done because their kids go to the same schools. They belong to the same churches. Yeah. Their lives are going to be a wreck, whatever a lawyer does in that old paradigm.
Yeah, and there are certainly plenty of ways in which the emotions of, say, a Steve Jobs had an awful lot to do with the existence and the conduct of the Apple Microsoft tensions, Apple anybody tensions.
Yeah.
Have I lost you?
I think I'm here. Have you lost me? Oh, here I am back again. Yeah. So, human beings are doing all of the work of corporations. We know that corporations are not people and that it's people who further or thwart their interests. And so, I think it remains true that any lawyer can benefit from discoveries they can learn about in integrative law. But Steve Jobs is going to would have continued to be Steve Jobs no matter what the lawyer's skills were. Mm-hmm. and the shareholders would expect what they expect. And all of that has very little to do with fractured relationships, I'd say, probably.
That's the total conflict thing.
I appreciate your approach to can we as professionals benefit from this learning, as opposed to is it something that we must know in order to go forward?
Yeah, and so I know that I'm staking the goalpost way out from where it is now to say that I see this as an emerging ethical mandate, but I do. And we know that the model code, the ABA model code, is a growing living document. It doesn't move out ahead of the culture, but it does respond to cultural change. And I think that this is a really big shift, that lawyers who have been working in much deeper ways with personal conflicts, mainly in the area of family law, collaborative law in the family realm, we're understanding that we are changing the notion of what the responsibility is of a lawyer. And with that, I think will come what are now comments to the model code about lawyers' responsibilities are going to move right up into ethical obligations. If I have anything to do with it, it's going to happen sooner rather than later, I'm hoping. There you go.
I suppose I'm curious about responses, reactions, reception.
About integrative law?
Yes.
That's a really interesting question. And to tell you the truth, I have been very surprised at the reception, for better and for worse. When I first started teaching any of this, I taught with a remarkable psychiatrist named Tom Lewis, who wrote an amazing book called A General Theory of Love. He and I taught together at Pepperdine at the Strauss Dispute Resolution Institute, and we devised a course, which is where I started learning about this realm, that I assumed would be of greatest interest to collaborative lawyers, because we find ourselves out at the edge of needing these understandings and skills and knowing that we need them, which is kind of unique in the legal profession, not the needing, but the knowing that we need. So I thought that course would be filled up with experienced collaborative lawyers, but that wasn't the case. The people who responded most quickly were commercial mediators. They were fascinated by this and knew that it was central to the work they wanted to be doing. So that was one surprise. Another surprise is that some of my most esteemed colleagues in the collaborative community, who I respect enormously, have responded wonderfully about this work of the Integrative Law Institute, and others have looked at me politely and kindly, but with a large question mark on their faces, just really not seeing how this has much to do with the work of a lawyer. So it certainly is keeping me alert, because I can't expect anything as I talk about this. I never know who it is that's going to say, this is amazing, of whom there are a lot of lawyers, and which ones are going to say, oh, but where does the law fit in? Which is a reasonable question.
Yeah, there's, I'm seeing that as well as I'm listening to you. The prospect of, there is a huge appeal to the type of order and completion that we are used to as attorneys. The notion that a resolution fits within the four corners of a piece of paper, and at that point my job is done. And it's,
Do you suppose that has anything to do with our self-selection into the profession, because we're the kind of people who really need that, and we're really good at making arguments that can do that?
Well, I'm sure that those of us who enter this bastion choose it for at least partly for that reason, although there are other reasons as well. I think we come in with all sorts of motivations of helping people, but I also think
I know from the work of our colleague Susan Dykoff that there is kind of a typology of lawyers. It's a bell-shaped curve. There's a whole lot of diversity among lawyers, but the large bump in the bell-shaped curve that accounts for most of us is way, way different from how the general population looks in terms of our discomfort with emotion and our prioritizing reason and verbal processing through the mind, through thinking. And that isn't really how people do. That isn't how most of the population embraces reality, and that isn't how people in fact solve problems. So there's a little bit. Well, go ahead. I would say that there's really a kind of a perverse paradox there, that those of us who have self-selected into doing the kind of work that involves deeply irrational processes, not only on the part of our clients, but really ourselves as well, have little or no patience with or comfort with, you're an exception, but for most, comfort with the realm of the emotions. It makes for a whole lot of possibilities for integrative law.
Yeah. I've also always thought that there was a component of the law itself, just the way it has grown, that was about the rest of society. In other words, the parties involved in a conflict, as to the rest of society, most of the rest of society really just wants them to be quiet already. Be done.
Yes and no. That's another interesting paradox. Because on the one hand, any of us who've done family law in the courts know that the courts are underfunded, they're overcrowded.
Right.
Even the best family law judges can't devote enough time to the calendars they're assigned. And so the biggest priority is get out of my courtroom fast. It always is. And go out in the corridor and resolve this. And, one lawyer in a basic collaborative course I was teaching, he was struggling with the concept of self-determined resolution by clients. And with the inefficiency and messiness that would inevitably be involved. And he said, any two lawyers who know their job can spend 10 minutes and on the back of an envelope, they know where the case is going to resolve. So why not just do it? So there's all of that. But then on the other side of the spectrum, at one of our very early the International Academy of Collaborative Professionals, we had a speaker who was a law professor from Quebec, I think, or Nova Scotia, who was very troubled by the emergence of collaborative law because she had skepticism about the impact of so much private ordering of disputes on the development of the law itself, which I thought was the exact wrong.
Go ahead. I'm sorry. What?
Getting dark in Chicago?
Yeah, it's dark. And when I'm on the screen, as I am again now, okay, I was getting kind of ghoulish, so I needed to add some light. Sorry about that. Sorry that I distracted you.
Well, anyway, I was talking about the tension between the necessity that judges have of processing cases quickly and getting people out of their courtroom fast, even if they're good judges, with what's, I think, more than a few law professors and maybe some other people interested in development of the law might say is a threat to the increasing evolution of the law as it's written in the law books by our emphasis on the private ordering of conflict resolution without reference to courts and certainly without reported appellate decisions. But a law professor who spoke to our collaborative community at one of our early gatherings of the International Academy of Collaborative Professionals actually spoke about that, about how if we were to become dominant in the field of family law, helping people resolve their problems entirely outside the courts, well, what would happen to the law? It would never develop. And the consensus of the community about what's right and wrong wouldn't be built into our work, although I think that's nonsense because everybody who comes to us is a member of a community and they've got a Greek chorus in the background telling them what they think.
Yeah.
But in any event.
The notion, it seems to focus on the notion that what will work best now is simply what has always worked for some other people in years gone by. And there's also a notion that I've always picked up on, that I perceive, that basically these people are incapable of reaching an agreement. And we have to.
If they are.
What?
If they do reach an agreement, there's a whole faction that believes, for example, that women are likely to be oppressed by men, that undue influence is inherent in the process. I don't want to go off on that because we've talked about that in many other contexts, but I just don't buy it. If you have very good professional services of the kind that we're learning to offer, then I think the chances of somebody, let's say, who's experiencing undue influence, that person is much more likely to make a sound decision with the kind of support and process that we offer than without it.
I agree. And I had a conversation earlier. I had a fresh out of law school woman contact me looking for just thoughts about collaborative practice and how could she get involved with it. And she shared with me that someone else she had spoken with, and I know you and I both know this is an old dialogue within the collaborative practice community. Another professional, not a collaborative attorney, urged her that no, she shouldn't even think about collaborative until she's done several years of litigation work. And
well, let's save that for another conversation.
Yeah. I only brought it up here, not as to whether or not it's true, but for this, in connection with what you were saying, in terms of there's still this notion of binding precedent. And unless you know what the precedent is, unless you have experience with that, then you can't be of service to let's say a divorcing couple who's trying to figure out how to restructure their family. You have to have experience with how other families have done it, or you can't be of value.
I certainly don't agree with that proposition, but I'm not sure that that's the end of the story in talking about having some years of conventional practice under your belt. Mm-hmm. If we were to fast forward to a point, 20, 25, 30 years from now, in which out-of-court self-determined resolution of personal disputes was far more normative, which I think it will be, then I don't think that there would be any need for anybody to ever go near the court system except for a very small percentage of lawyers who might be like barristers, who specialize in the 3 to 5% of people who for various reasons can't solve their own problems. But right now, given that we aren't there yet, mm-hmm. I think there are things that a lawyer who's been there and done that can say with confidence that somebody who hasn't can't. But again, I don't want to go there. Right? That's a conversation I'm glad to have with you.
Yeah. So what I hear you offering then is a kind of a sliding forward, where we're moving from precedent-driven to individual circumstance-driven. And part of what informs that movement is and will continue to be the integrative law movement. The more.
Yeah. I see the integrative law movement as out on the edge, the avant-garde at the moment, for the movement of our profession into the 21st century as relates to personal disputes. That, this is where it's at right now. This is where the growth is happening. But it doesn't mean that I think that the law is entirely irrelevant at all. The metaphor that I love is one that our colleague George Richardson from California has given me permission to use. It's a great metaphor. He says that, in conventional practice, the law is like the sun in the solar system. And in the kind of practice that collaborative lawyers and integrative lawyers generally, of which collaborative lawyers are a subset, are offering to clients, we're presenting the law as the sun in the Milky Way. It's another thread. They need to know about it. I mean, if for no other reason than to inoculate them against what their fishing buddies are going to say when they talk about it later. And also there are people, I'm handling a case right now with a client who has been cowed during a long marriage by her husband's way of looking at the world, and is at the point where she sees that she can stand her own ground and make her own decisions, but she's needing a reference point for what other people do so that she can test where she stands personally with reference to where her husband stands and where other people tend to stand on these questions. And so the law is helpful about that, not as the frame, the guide, the straitjacket, but just as another thread of information.
And understanding who, when, and how an individual person might need that reference point is part of the learning that integrative law is bringing to the fore. Am I right?
Precisely that.
Okay.
Yeah, that would be the kind of conversation that we would have in an extended integrative law workshop, where we're playing with the concepts in actual role play experiences. We do that, of course, in collaborative training as well. But for me, at least, I mentioned before my own trajectory in coming to this. For me, my work, my learning curve as a lawyer has been to walk through the doorway into doing collaborative law and to get more and more deeply engaged with the actual nature of human conflict as distinct from the abstract nature that you find in court processes. And then to take it laterally now to the rest of the profession that's involved in personal disputes beyond family law.
What I'd like to do at this point, if you wouldn't mind, I think we could go on this for a while. I know I'd enjoy it, but I want to bring it to a more practical point. I know you've taken the reins of the Integrative Law Institute at Commonweal. So I'd ask you can you tell us a little bit about the Institute, its relationship to Commonweal and what it's doing?
Yeah. I created the Integrative Law Institute because I realized that I really want to devote myself full time to bringing this approach to personal dispute resolution, personal conflict resolution beyond family law to the many other areas of law where the fuel is in a fractured relationship, the fuel for the problem.
Okay.
So to do that, I needed to not be paid hourly by clients. It's just not possible for me to launch this movement that way because it's not self-evident to lawyers outside family law that this is important. It's something that they need to be shown. So going into a nonprofit mode seems sensible. And in this economy, it's not sensible to start a whole new nonprofit organization that has its own infrastructure and administrative costs. I was looking for an existing, well-established organization, a nonprofit, where I might find a comfortable home, and Commonweal is it. It's a wonderful place for the Integrative Law Institute. Commonweal is a remarkable program that it's very difficult to find words to describe. Its founder and director, Michael Lerner, who's one of the early MacArthur Genius Award winners, just last week was talking about Commonweal and said, nobody can describe what Commonweal is. But one of the things it is a home for people who are out at the edge of their own areas of endeavor to heal the planet and heal the culture. And Commonweal makes it possible for people like myself to do what we want to do by way of healing in various professions and other fields, while providing the infrastructure and support to do it. It's a brilliant concept. It's a brilliant place. There's a URL if people would like to find out both about Commonweal and about ILI, the Integrative Law Institute. I think you're going to flash the URL on the screen as I speak it, which is www.commonweal.org/ili.html. That's where you'll find it.
I will have links when we post the video. Yeah. Thank you.
So people can find out about Commonweal there. They can find out about ILI, and ILI's blog is located at integrativelawinstitute.org. We've also got a Facebook page. We have a group on LinkedIn, the Integrative Law Institute group, which is a pretty lively place. And we are launching our first training workshop this January. Our intention is to transform the legal profession, one lawyer at a time, by running workshops in the various vectors of integrative law in major cities all around the country, starting with San Francisco on January 12th. And we're going to offer certification programs in integrative lawyering, which will involve a little analogy is if you think of Eagle Scouts, which I was not ever. If you think of the Eagle Scout model, where there's a whole spectrum of knowledge that an Eagle Scout has to have a little bit of, I guess it's called badges or whatever, and then they specialize in one or two areas to show competency as an Eagle Scout. Well, integrative lawyering is going to involve general knowledge of all of the vectors that constitute integrative law, and then specialization in a few of them. And for the specialization part, we're partnering with other nonprofit and similar organizations so that people won't be studying only with me at ILI, but also can develop expertise by working with psychologists, neuroeconomists, mindfulness teachers, to go more deeply into the particular vectors that they're most interested in. Now, you might say, why does a lawyer need to be certified as an integrative lawyer? And my answer to that is that potential clients, people who have got problems, need to know that there's a new kind of lawyer who's not going to do harm to them. You know that the courts are clogged with pro se, self-represented clients in personal disputes. And the general thinking is it's because they're afraid of us, because they know that it's likely that many lawyers that they might encounter would make the problem worse rather than better in the course of providing old-fashioned legal counsel. Not meaning to, but it's kind of the nature of the beast. So my intention and mission is both to teach lawyers an overview and then mastery of some parts of the vectors of integrative law so that they can be certified as specialists in integrative law and know how to deliver these services to clients. And then to provide badging and an online community and search engine optimization and all of those good things through ILI, and to help lawyers in our retreats and workshops to do a kind of self-reflective process and strategic planning process to make a shift for themselves into full-time integrative lawyering, and then for clients to be able to find them. And the certification badge, is a tool so that it helps lawyers to self-identify, to identify other like-minded lawyers, and to make themselves known to the clients who need them.
You mentioned the notion of self-reflecting process. That's not frequently involved in a lot of lawyer trainings.
No, it's not. It's not involved at all in most continuing education. By the way, our programs carry continuing legal education credit, and now I think we're going to be able to also offer credits to mental health professionals. Although the programs are not designed for them, we've been getting a lot of inquiries from them asking if they can come too. And so we'll probably offer credits as well for those who want to come and see what lawyers are learning about their field. What did you ask me?
That was it. I was commenting on, what jumped out for me is the notion that as part of this training in lawyering skills, there would be a self-reflecting component.
I think that's essential because this really involves seeing that I myself am maybe the most significant variable next to my client and the person that my client's struggling with that's going to change the potentialities for a good outcome, a deep outcome that involves healing. And that means really changing what we believe the job description is and what the skill set is that we've got to bring into the room. And that means self-reflection. It's not primarily a cognitive process to become an integrative lawyer. There's a great deal of substantive knowledge involved. In the end, you've got to make a personal commitment to yourself that you want to do this rather than that. And that means self-reflection and then operationalizing it with a strategic plan. Mm-hmm. And we're going to teach that in retreats for people who are seriously interested in this.
It flies in the face of what we discussed earlier, the historic perception of the lawyer as the dispassionate, objective, peel-away agent from the client. The attorney in the classic view has.
Being realistic. Oh,
I
lost you there.
In that classic view, the attorney has no self to reflect upon.
Right, you're only neocortex and tongue. But we know from our own experience that there are lawyers who, when we see them coming, we know that nothing good is going to happen, no matter what our rational skills are, no matter how skillful a conventional advocate we are. There are lawyers who are trouble on wheels. Not most of us, but definitely some of us. We all know lawyers like that. So how can we account for that if it's all about rationality? Some of those lawyers are technically the most skillful lawyers in town. They're really smart and the judges like them because their briefs are impeccable and they don't misrepresent what cases say. So how can it be that those are seen by judges as good lawyers and we know that they are going to make anything useful for either party to a conflict? Anything useful will be impossible. We know this. They're going to take all of both parties' money on pointless maneuvering and procedural disputes, and nothing good will happen. So if you start from that, which I think any lawyer will say yes to, they are bringing themselves into the room. The harder thing to see is, so am I, and so are you. And it's not obvious to me the ways in which I cause problems. But if you and I were working on a case together and we trusted each other, you could help me see that. So this is where self-awareness, self-reflection, communication skills, mindfulness practice, these are all vectors of integrative law. Because the person who comes into the room needs to reflect on who they are, who they want to be, and what their job is. And what's happening below the level of neocortical storytelling, what's really happening when I come into the room? What am I really bringing? I'd be the last to know. So I need ways to find out.
Well, it's very exciting that the notion that you are offering attorneys the opportunity to recognize that when I'm involved in a conflict, I am a party to the conflict.
Yes.
Yeah. So I bring myself, and if I don't know who I am when I walk into that room, or if I pretend that I'm not being myself, but instead I'm being simply objective.
Which most of us do until we stop.
Right.
When I wrote my first book about collaborative law, I had a 4-part matrix, which serves me well whatever I'm teaching, and it serves me well here, that there are 4 questions for shifting paradigm.
Mm-hmm.
Who am I? Who's the client? What's the task? How do I do the task?
Mm-hmm.
The answer changes.
I still borrow from that freely when I do my own pieces. Always with credit.
Oh, whether or not, I'm glad it's useful.
Yes. It was a stroke of brilliance when I first saw it, and it still remains that. I'm mindful of, the movement of time, and I wanted to, I am going to have down, below around the embed of the video, more information and details and links to the program.
May I say the name of it?
Yeah,
May I tell you the name of the program?
Yes.
Because it's kind of fun. It's Neuroliteracy 101 for lawyers, mediators, and judges. And that kind of captures what we're going to be focusing on there. Just one of the vectors, but it's a fun way to start. And it appeals to people who are neocortex forward, let's say.
Kind of the basic brain work.
Basically understanding the triune brain, understanding what the place of reason is in the functioning of the brain, and where conflict and decision making live in the brain, how all of that manifests in many ways, in our bodies, our voices, what the place of narrative is in all of that, storytelling, which is the realm of the neocortex, and how storytelling relates to dispute resolution, and other things that are a lot of fun.
Sounds like a good day. Is this a 1 day, 2 day? How long?
It's 1 day, 6 hours of continuing education credit. It's in downtown San Francisco, January 12th.
Okay, and I'll have the links and information on the page as well. Thanks again.
And I'm hoping Chicago may be our second venue. I'd love to come and do it there.
Well, we're working on that offline, aren't we?
Yep, we are.
Okay. Any closing thoughts you want to share? Otherwise, we'll.
No, I think we've really covered a lot of ground here, and I appreciate your asking the questions and digging in deeper and giving me an opportunity to talk about this. Thanks.
I'm always happy to do that anytime, and I thank you for all that you've brought in the movement. So we will talk again, I hope. And thanks to all you out there for tuning in. And bye.
Bye-bye.